It's a very, very serious issue, and you do not want to lie or misrepresent anything. You could end up getting sanctioned. It just will damage your credibility at the end of the day, and you really don't want to do that. It's just not worth it.
Well, hello and welcome to the Illinois Family Law Insider. My name is Jeff Hughes and I'm the CEO of Sterling Lawyers. We are an exclusive family law firm here in Illinois, and I have with me today my co-host.
Hi, I'm Katie VanDeusen. I'm the managing partner of Sterling Hughes.
And Katie, property and debt division in a divorce. I would love to share with our listeners kind of a high-level analysis on what they can expect as they move through their case, on how the judges determine how property and debt is divided up. So let's get us going with, there's been a divorce action filed and the parties have a fair amount of debt and a lot more property. And let's say it's been a 10-year marriage. Walk us through kind of what are the considerations that the judges will look at when making that ultimate order for property division.
Yeah, so I think the very first thing to consider is that you really need disclosure. So
Mhm.
typically, the first step in any case is you have to determine what exists. So we would go through and determine what properties exist. I would say bank accounts, investments, retirement accounts, any type of home that's owned, or even if it's vacant land or secondary property, or however many properties the parties may own. And then the debts that exist, whether that's a mortgage, credit cards, maybe even liens on a house or loans that exist. All of those things need to be defined. And
Mhm.
then the judge is going to want to know whether or not those things are categorized or characterized as either marital or non marital.
So, Katie, before we get to the part about how the judge looks at the assets and the debt, the parties, after the action's filed and the divorce is underway and that's everything's been properly done so far, the parties then are required to file with the court as well as with each other, right? A financial affidavit.
So typically, financial affidavits are completed and then exchanged. Certain counties require you to file them, other counties don't, depending on where you're practicing, just because there's a
Yeah.
lot of sensitive information on those typically. But
Okay.
yes, those would disclose all income, assets, liabilities, and expenses that a certain party has.
Yeah, and when we use the word affidavit, this is a sworn statement under oath, notarized. And if you lie on this, that counts as perjury, which is a really bad thing that you could have in the criminal courts, right?
Not only that, but I mean, technically, even in the divorce realm or domestic relations, you could end up getting sanctioned.
Yeah.
It's a very, very serious issue, and you do not want to lie or misrepresent anything. You really
Yeah.
want to do your best to remember and recall everything, and it's better to include something and put a note on it or a clarifying note to the judge or
Mhm.
the other attorney than to overlook something or forget something,
Yeah.
because it just will damage your credibility at the end of the day, and you
Yeah.
really don't want to do that.
Yeah. I've told clients so many times that your most precious asset as you're going through divorce is your credibility. If the judge doesn't believe you, you get sanctioned or you get held in contempt or something, you are torpedoed from a credibility standpoint. And you will
Abs-
lose on every close thing there on out.
Absolutely.
Yeah. So, like, by way of example, I had a client one time who inherited a legitimate property, some real estate. It was up north, and they didn't put that on their disclosure, their affidavit. And they just said, "Well, I assumed I don't need to do that because it was inherited. It's still in my name." That's the wrong answer. You got to
Correct.
put it all in your disclosure affidavit, right?
Put it all on there. And even if you're wondering, you really should put it on or have a discussion with your attorney as to whether or not that's something that would or wouldn't qualify as ownership. Um,
Right.
you should always put it on for the most part, because, again, if you don't, it is just going to look terrible if the other side brings it up, or trying to expose the other person for lying or not being truthful. It's just
Yep.
not worth it.
Yeah, the penalties are really, really stiff on this one. And then with respect to the types of assets that you put in your affidavit, just generally speaking, this would be all titled assets. Anything has a title to it, right? as well as those that are of value that don't have a title, like an art collection or something, or like I love guitars and I have some expensive guitars. Don't tell my wife how much I paid for them, but so I would need to put those on there as well. Even if I don't know the exact value, disclose that I own that piece of art. Um,
Absolutely.
right? Okay.
Yeah, absolutely.
And likewise with respect to debt, that would be all titled the stuff, easy stuff like mortgages and credit cards and school loans, things of that nature. But also, if you owe money to your Uncle Harvey, that needs to go on there as well.
Definitely.
Okay. So once the affidavit has been exchanged and it's been accurately filled out, of course, we talked about the penalties for that if you do that wrong. What would be the next step in the process?
Yeah, so the next step would be just making sure that you have a complete affidavit. If there's any other additional discovery that you may want to pursue or do to discover additional assets or liabilities, you really should do that early on in a case
Okay.
versus waiting until the end of a case or deciding to do that kind of at the last minute.
So
And
discovery, what does that mean to someone who's never heard that word in a divorce?
Yeah, so formal discovery, there are certain tools that we can use to discover information from the other side, whether
Hmm.
that is a formal discovery request, which is like a notice to produce, where the other side has to produce financial records,
Yeah.
or um, interrogatories. That's where the other party has to respond to questions under oath,
Okay.
or a deposition where you're asking the other side questions that they have to answer under oath,
Mm,
or subpoenas, or even, let's say, subpoenas for records to certain entities like banks,
okay.
where they have to produce records on behalf of that party.
So
So
if you
those,
suspect that your ex is hiding a bank account and you think it's at Chase Bank, you can actually subpoena Chase Bank to turn those records over directly to you.
yes, you can, as long as you've done an affidavit and then
Yeah.
you issue a subpoena, as long as it's relevant in the case, yes, you can.
Now, I had a case one time where we were certain that he was hiding assets in a safety deposit box, and that you could put like gold coins in there. You could put a lot of stuff in those boxes that are valuable. And we didn't say a word to the other side, but we knew that the scoundrel was hiding stuff in a safety deposit box. And I remember we went to court and we had a scheduling conference where the judge was going to give us an order for how the case was going to proceed from a timeline standpoint. And we
Mhm.
said, Judge, there's one more thing. We think he hides assets in in his safety deposit box. Can you enter an order right now for us to meet at the bank and open that together? And the judge did it. And so we go to the bank and we're sitting out in the parking lot and the other side rolls up, and we felt like we're opening up Al Capone's vaults or something. It was like the biggest moment. And wouldn't you know it, we get in there, we open the safety deposit box. He has nothing but some old paperwork in there. But boy, I felt like the lawyer of the year. I just couldn't close the deal on finding the gold coins that we were after. So
Yeah,
there's a lot of mechanisms you can go through to get the judge to support you in finding stuff that someone has.
there definitely are, but hopefully in that situation, Jeff, that client knew that you went to the ends of the earth to make sure
Yeah.
that you double
Yes,
checked that there
he did.
wasn't something in there. Sometimes that peace of mind can honestly help you resolve cases. So it
Yeah.
is something to consider. If someone's bringing a valid concern to you, you want to make sure that you're investigating it as their attorney.
He was one of those guys who always acted like he was bigger than he was. He wanted everyone to think he was like money bags walking around. He was he didn't have 5 cents to rub together. That's the reality at the end of the day. But my
Yeah,
client kind of bought into that whole myth that this guy is loaded when he was just a con man, is really all he was.
yeah, it's tough.
Yeah.
Those situations are so tough.
Okay, so I keep interrupting you. We're back talking through the disclosures are done, the affidavits are filed, or the court receives them. The judge then needs to make a determination on the characterization. Walk us through what that looks like.
Yes, so they would end up deciding or characterizing whether certain property and debts are marital or non marital. And how they categorize those things can have an impact on their decisions and how they allocate certain property or debts one way or the other.
Is that done in a hearing where the
So
judge actually takes testimony? What happens? How does the judge do that?
I mean, it could be a multitude of different ways. So it could be at a pretrial conference where the
Mhm.
judge hears the arguments from both sides and then
Okay.
makes a recommendation on how they would categorize certain property and how they would allocate that property.
Mhm.
Or you could go forward to a hearing where the judge is going to take testimony and then gather evidence with regard to what to decide in terms of the
Mhm.
property.
Okay.
Typically, that happens at the end of a case at a trial.
Okay.
Um, there are some exceptions to that, like if there's been a prenuptial agreement entered into, or if there is some type of motion on file asking the judge to make certain findings that premarital property is in fact premarital. So
Mhm.
those things can be done, but most of the time the judge is going to do that at either a pretrial conference or a trial.
Okay. Got it. So if now realistically though, most parties they'll just simply agree on the majority of their assets as to the characterization. Then if there's an issue for the judge to decide, it'd only be on a few that are in dispute. Is that right?
You would try to focus it as much as
Yeah.
possible and try to
Mhm.
resolve things through a settlement before it gets to that point. Definitely.
Okay. 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 So when the judge does have that pool of assets to divide, what's the process for that division? What does it look like if a judge is asked to do that?
Yeah, so a judge, Illinois is not a community property state or an equal state. It is what's called an equitable state, which means that
Mhm.
the judge has a lot of power and leeway to determine and to decide what they feel is fair and equitable
Mhm.
in any given case. So
Okay.
they are not bound to equally divide everything. They get to determine what they feel is appropriate in any given situation. So, again, it doesn't have to be 50-50. One person or one spouse could potentially ask for what's called a disproportionate share of the estate. And that could depend on several different factors like length of marriage, earning
Mhm.
capacity or earning potential of the parties, what each party is being awarded in terms of the divorce. If someone has a significant or substantial non marital estate in comparison to the marital estate. So, a lot of different factors kind of go into play, and a judge really has a lot of power to decide what they think is fair.
Mhm. Yeah. So that issue of fairness, boy, that could be different. I mean, what I think is fair, you may not think is fair, and the person down the road from you doesn't think it's fair. So that's really is a big component of discretion with the judges on that, right?
Absolutely.
And so they're basically told, am I getting what you're saying here, that the lawmakers have said, judges, you're in the counties, you're with the actual parties. We want you to decide what's fair based on what?
Based on just what's equitable in terms
Mhm.
of what's being presented to the judge. So the judge gets to determine what exists, who's
Mhm.
going to be retaining what, how is that going to impact the parties, and are there any special considerations to make in this case that would warrant a disproportionate share?
Yeah.
I mean,
Okay.
a lot of times I feel like it really just depends, but I think a judge is going to look to see whether or not there's a house and whether or not a house should be sold or a buyout should occur. Retirement accounts are going to be allocated however the judge thinks is fair. Most of the time, they will at least initially default to an equal allocation, but that by no means that the judge has to go 50-50. Not in Illinois.
That's when your credibility comes into play because if the judge doesn't believe you, you're likely to get pounded.
I mean,
If you're,
yeah, it could absolutely have an impact on your particular
yeah.
case. And when it comes to, Illinois, you could also have certain things called like dissipation. So that's where you're using marital funds on a non-marital purpose. And if the
Hmm.
judge finds that the marriage is entitled to a reimbursement or to be made whole, then that could also have a financial impact on how the judge allocates things or divvies things up. It
Yeah.
really just is very fact specific and depends on, length of marriage, again, earning capacity, what each party earns in terms of income,
Hmm.
what each party is anticipated to receive after the divorce. If someone has a substantial non marital estate,
Yeah. Wow. Well, thank you, Katie. That's been really informative. And I know that this opens up probably a whole can of worms and 15,000 other questions on property division. I know that we have other videos that kind of go deeper down the rabbit hole on a few of these issues to help clients get a better feel for how their case may end up if they go through with the full divorce. So thank you for co hosting with me today. It's been a pleasure.
Thanks for having me.